So I wanted to discuss with you a decision that just came down yesterday on Wednesday, August 17th, from a federal appeals court out of Colorado, the 10th Circuit, where they reinstated some claims with respect to restrictive covenants that had been signed by former employees that had previously been dismissed by the trial court. Name of the case is LS3 Inc. against Cherokee Nation Strategic Programs. Cherokee Nation being the competing IT company where both they and LS3 had been vying for a federal contract with the USDA. And what ended up happening was that a slew of LS3 employees went en masse over to Cherokee Nation, and then Cherokee Nation ultimately ended up landing the contract with the USDA. So LS3 turns around and sues and says, hey, wait a second. You took a bunch of our intellectual property, which was confidential, and you unfairly used that to win this contract with the USDA, which was really in our hopper, so to speak. The trial court threw it out, saying, no, the contract had already been lost. So to borrow an old term, no autopsy, no foul. And that's an important point because unless you can show that but for what the defendants did, you would have gotten X, then in theory, there's no damage done by whatever they did. So the appeals court said, no, the trial court went a little bit too far because it turns out that it's not so clear that the decision had already been made to award the contract to Cherokee Nation. So at least at the pleading stage, that claim should still survive. The other piece that's also interesting is that the appeals court said, but that part of the claim that the trial court had thrown out with respect to the claims that trade secrets and confidential information had been stolen, they said no, because you LS3 did not identify any specific trade secrets that were actually stolen. And you can't just sit back and say, well, we'll kind of figure that out in discovery and see what, if anything, was actually taken. They said that's not good enough. Even at the pleading stage, you have to identify what specific trade secrets were stolen. So again, I just think this is an interesting decision from the perspective of laying out what are the criteria that a plaintiff needs to establish or even at least allege in the first instance in order to have their claims survive and live to fight another day. If you have any other questions about restrictive covenants or how it will be viewed by different courts across the country in terms of litigation, please feel free to give me a call, 516-791-5700. This is Jonathan Cooper, and thank you for watching.